This is the Orlando Sentinel Editorial Board, and we are meeting today with candidates for County Court Judge Group 5. There are 3 people in this race, and there is no incumbent. So we are going to be spending a little bit of time talking to you, getting to know you, and hearing about your philosophy regarding judicial matters. We will not ask you anything that violates the canons of judicial conduct. So we'll, I guess, go ahead and get started. Scott, did you have the first question?
Sure, I can go first, and I will tweak this for each of you guys since I know you have a little bit different background. But thank you for joining us. As Krys mentioned, I'm Scott Maxwell, a columnist with the Sentinel. And one of the things we are usually asked is sort of why you decided to run. It's my philosophy that a lot of lawyers who finally decide to run for judge do so because they have appeared before a judge and at some point in time thought, yeah, I could do that, or maybe I could even do better than that. So I'm curious about what prompted each of you two to run. And then the tweaked question is for Mr. Lester, is I think you've done this before and decided to step down why you're coming back. So maybe we'll start with you, Mr. Lester.
Thank you very much, Scott. As you noted, I was an attorney for 16 years prior to actually becoming a circuit court judge. I practiced all around the country, throughout the state. Did some of the biggest cases here in Central Florida, the Bob Govern case when I was a young attorney, and kept on working. Decided that I had learned a lot from the judges around the country, wanted to run for circuit court judge, did so for 24 years, very successful, got high ratings, top rated circuit criminal court judge for 9 out of 10 years, enjoyed it immensely. Because of the constitutional glitch, had to retire, retired. When I was out, I was starting to work again. I was going around to law firms working. They told me, what are you doing? You were made to be a judge. You're a great judge. Go ahead and run for judge again since Judge Schott is retiring. And that's what brought me back. I think I still have a lot of tread on the tire. I think I have a lot to offer people. It's one of those situations where why not an experienced jurist in county court where most normal people, regular people are? Why can't they have somebody with all the experience of a circuit court judge coming down to county court? It's sort of like if your child got injured on the playground, you took him to the emergency room, and instead of the regular internist or somebody who you just had who was a new doctor, the chief of surgery came down and said, I've seen a broken bone or two. I understand what's going on here. I can do that. I believe that my passion for justice still exists very, very strongly, and I think we can get the job done.
Okay, thank you very much. Ms. Buie?
Good afternoon. Thank you. Being a judge is something that I've always desired to do. Again, when I was younger, my mom told me that I needed to be a lawyer because I asked so many questions. And from there, I think I decided that I wanted to be a judge. My mom planted the seed in me to be a lawyer, and being a judge is a step that being a lawyer is a step that I needed to take in order to be a judge. Being a judge was something that I desired to do. I desired to be a judge because I want to make sure and ensure that fairness is on the bench in Seminole County, continues to be on the bench in Seminole County. I believe we have very good judges here in Seminole County, and I just want to be able to serve my community. I grew up here in Seminole County. This is where I'm from. My mom and my family moved here when I was 3 years old, and I want to just come back and be a part of my community as a judge. I believe that fairness is and being impartial is key to being a judge. And I believe I have those qualities that it takes. I believe that I have the quality to listen. I believe I have a quality to be fair. I'm honest, to be impartial. And this is a dream that I've always had. And I'm just trying to fulfill that dream that I had to serve my community as a judge.
Okay, thank you very much. And Mr. Swenk?
Yes, so my name is Erik Swenk. My family has lived in Central Florida for 75 years. College Park specifically, that was where I was born and raised. Extended family has lived in Seminole County for 35 years, and my wife and I have lived in Wekiva Springs since 2008, last years of law school, and that's where we've resided since. The main reason why I feel like I'm being called to this, to the bench and to this role is a combination between professional and personal experience. I always start off with a story. When I was 15, 16 years old, I got caught up in the wrong crowd and ended up in court myself. And that was my first experience, was in front of a judge. And I was fortunate enough to have a lot of family support and people around me to help me out and get my life straightened back out. But I remember leaving the court that day, realizing that a lot of people that were there with a different skin color and a lot less charges did not have the same opportunity to leave court. It didn't have a huge impact on me then, but it certainly did down the road. Again, I was able to get my life put back together, back on track. And this was, again, 15, 16 years old. Professionally, and I'll come back around to the personal reason in just a moment. Professionally, I ran my own practice for a number of years in Central Florida, both in county and circuit court. I was also a volunteer attorney with the state attorney's office in the Ninth Circuit, and went through the law enforcement academy following my dad's footsteps as an Orlando police officer. After a number of years of running my own practice, I ended up with the Office of Appeal Hearings, which is where I've presided over administrative court cases the past 5 years. We preside over a largely pro se dockets, people representing themselves. They don't have the fortune to have an attorney there for a lot of the cases that bring them into our courts. Of course, without having an attorney, there's nobody there to really govern a lot of the emotions that are involved and guide them through the processes that are necessary for a formal proceeding. So it takes an incredible amount of patience and a particular type of judge to do that. And that's what I have 5 years of experience doing. The personal reason, briefly, I'm sorry. The personal reason, real quick, and I'll try to keep this brief, was a battle with alcoholism for 15 years. My sobriety really got me into community service over a number of years and getting involved in a number of different organizations, ultimately leading to my belief that the way that I can have the largest impact on the community with tying in my professional and personal experiences is on the bench, specifically the county court, where we find a lot of people who don't expect themselves to find in court, to find themselves in court, and facing a lot of life challenges that I've personally faced and can identify with and help on a personal level, not just ruling on a case, but addressing some of the underlying issues.
Okay, I appreciate that. Thank you very much. And by the way, I understand that lawyers can tend to be a little long-winded. I'm the son of a trial lawyer, and my father could take the Jesus wept version of the Bible and turn it into a 5-page manuscript. So I get that.
I apologize about the brevity.
But I did want to start with Mr. Swenk. Back to you because you brought this up. A good number of litigants appear before a county court judge with no lawyer standing by them. And as a judge, it is a constant challenge to balance staying within the boundaries of the law and fairness, and not disenfranchising pro se litigants. How do you keep that balance? How would you keep that balance? And what are some of the challenges you see?
There's definitely challenges with that. It's a judge's role, obviously, to be a neutral party. We're not there to advocate on either party's behalf. We're there to hear the case and then interpret and apply the law to the facts as they're presented. However, with pro se litigants, they're not familiar with the rules of procedure. They're not familiar with the evidence code. And it's still incumbent on a judge to build a record by which a decision can be made. So we have to guide litigants to an extent on what can be presented, how it can be presented, so that we can build that record. For 3 years, I've been a hearing officer. In the past 2.5 years, I've been a hearing officer supervisor. So I currently supervise 5 other hearing officers. I help train all of our hearing officers throughout the state. We have 23 hearing officers throughout the state, both on building records, conducting hearings fairly, and not overstepping those bounds. One of the biggest tools that I teach our hearing officers is asking open-ended questions. If you ask a question that allows the party to answer, that you're not really providing them any lead or any information that you're trying to glean necessarily, it's a good way to build a record where you're not overstepping that bounds and advocating. Because if you ask a question pointedly, then you're overstepping that bounds, and you're also, getting away from that neutrality. One of the other things that I also teach our hearing officers is, and instruct them, is making sure that you're listening to both sides and you're asking questions of both sides. You know, that gives the appearance of neutrality as well. You don't want to come off as favoring one side or the other, because ultimately we're there to hear both sides. And ultimately we don't have, you know, any skin in the game. You know, I mean, when I'm ruling over a case, you know, I'm not, it's not my belief or persuasion that's governing that. It's the law and it's the facts that are presented.
Thank you. Ms. Buie, would you mind giving us your insight on that?
I'm sorry, can you repeat the question for me?
Yes. Handling pro se litigants, people who are standing in front of the court without an attorney, can be extremely difficult for a judge because they have to follow the law, and yet they understand that a litigant without an attorney is at a very deep disadvantage. How do you balance those two things?
Well, I think the first and most important thing is that you have to remember that you are there, and I agree with Mr. Swenk, that you are there to get the facts. And however the parties present the facts to you, that is how you take the facts. You do need to, I guess what I would do is to make sure that the facts are being presented according to both sides, by both sides, both parties, making sure that each party is being heard. I think what happens is a lot of pro se litigants, they feel that they're not being heard. I think they feel that, you know, because the attorney gets to talk and, you know, sometimes they don't get to talk or they don't get to say anything. I think that's one of the most important things, is to make sure that they are being heard and to listen to them as they say. Again, they may not know the rules of procedure, and, you know, starting out as an attorney, you kind of get messed up on those as well. So, but, you know, a pro se litigant does not know the rules of procedure. They do not know the rules of evidence. And so we have to remember, as a judge, I would have to remember, if I am in that position as a judge, that I have to give them the some leeway to make sure that they get their point out, so that they know that they're being heard, so that they know that the evidence that they're presenting is not falling on deaf ears, that when they say what they say, I will listen to what they say, as well as what the lawyers say. And then I will apply the facts, I will apply the law as it is given to me, and make a ruling based on that. But definitely making sure that everyone who comes before me knows that they are being heard.
Thank you. Thank you very much. Mr. Lester, we can
Yes.
hear from you on that topic.
Well, after doing this for 24 years, I can tell you that I very rarely ever had a pro se person in front of me. And I'll explain this. First of all, this is county court. County court, 80% is criminal. In criminal, you make sure people have attorneys. I can arrange for an attorney there regardless of what everybody thinks, unless the person really does not want an attorney. You have some sovereign citizens, you have freemen, you have people from the Moorish Peoples Nation who want to make a political statement. They don't want to be represented. You're not going to change their mind. You're going to have some very robust individuals who think they are almost lawyers, and they are going to try their best to represent themselves. I usually have a standby lawyer for them, because when it breaks down in court, and it will break down in court, especially during the trial, they look to the standby attorney. The standby attorney comes up and helps them. The other folks, if they don't have the money, we make sure they fill out their affidavit. We get the public defender appointed. I look at the facts, and I usually save them for the last part of the trial docket. I sit down with the state, with the defense and the defendant, and I say, what's going on here? And I tell the defendant, don't say a word, just listen to what the state says. The public defender is usually there. I said, talk to him for a second, see what's going on with this case, see if there's a way to work it out. That's how it's done. When it comes to the civil matters, which are about 20% of the docket in county court, it usually has a commercial attorney there who's seeking to foreclose on some type of consumer account, be it a bad car loan, be it a used car that's being repossessed, be it a health club membership, which are very big about this time of the year because everybody stopped paying after their January health club memberships. And so they come into court and they sit down and they have what is called a ticker tape, and they have all the expenses and the costs associated with the account. You listen to the person say, did you sign the account? Did you make the payment? If they said yes, what is the big disagreement here? They didn't get the services provided, whatever. I said, well, there's a couple of ways to work it out. You tell the attorney to sit down and go over this with them. They do come back to court and they let me know what the disagreement is. I have trained attorneys for years on end how to explain this to people. And then I look over the costs that are associated with any complaint. For example, if a bank has a repossession of a vehicle, I look and say, you're charging them lot fees when you don't have a lot to have lot fees for. You're charging them lot insurance. You're charging them single interest insurance. These things can be stricken off. After that, you tell the person, if you want a trial, absolutely happy to have a trial. Explain it to them that they will be given all benefits under the law insofar as me being able to assist them as much as possible. And you go a little bit above and beyond what you're allowed to do, really, when you're doing these trials with these folks. You make sure they understand what they can put on, even if they don't put it on. And then I ask the other side to go ahead and explain. You give them every option. If it works out in their favor, it does. If it doesn't, you then go into the real meat of the issue, which is, how is this going to be paid? If you owe it, how are you going to pay it? You can still work it out for a stipulation in lieu of entry final judgment, which means you can make payments over time. Or if the person is just recalcitrant, doesn't want to pay it, then they're going to have a judgment against it. But regardless, you can assist them. You can't get them a private attorney necessarily in county court, but you have a reputation as a judge who sits down there and makes sure that the attorney who's representing the institutional lender is going to be able to go ahead and put the information out in front of them.
Okay, sir. Thank you. And if I could remind everybody, please try to keep your answers concise, because we want to get through as much as we can. And apologies to you, but I just wanted to ask that, because we want to cover as much ground as possible. With that said, I'll jump right into my next question, which is, can you give me a good description of what you consider to be essential to a judicial temperament, which is a phrase that gets thrown around a lot in judicial races, but I think everybody has a slightly different definition of what it means. Ms. Buie, if we could start with you.
Yes, what I would consider to be essential to a good judicial temperament is that the American Bar Association actually has defined what a judicial temperament is, and it's compassion, decisiveness, open-mindedness, sensitivity, courteous, patience, freedom from bias, and commitment to equal justice. So that's what I think a good temperament would be for a judge.
Thank you. Mr. Lester?
I think judicial temperament is creating an atmosphere in the courtroom which allows the participants to feel that they're being fully heard, allows the attorneys to do their best work and to feel comfortable. After all these years of doing this, if you are relaxed and if the attorneys feel relaxed, they put forth their best product and people are able to think clearly and make a good decision. It's not their best day in their life. If you can make a good decision out of a bad situation, I consider that to be a success. You have to create the atmosphere, and they have to have faith in you that you understand the mechanics of what's going on when they put forth their argument, and that they will be heard properly. And if there is a strong legal point that they want to make, that it will be understood by the judge. And that helps to create the atmosphere to where everybody feels they are fully participating in it. It's a relaxed atmosphere. It's not perhaps what people think of in the movie with a lot of tension. It's usually one where people can sit back and consider it and listen to what the other side is saying. When it comes to jury selection, I usually do that by picking the juries, by asking the tough questions, and allow the attorneys to put a little gloss on the apple, so to speak. So in that type of situation, I think that's what typifies temperament in the best sense of the word.
Mr. Swenk?
Yes, I believe the best definition of judicial temperament is patience, being able to listen to people, and keeping an open mind. In 5 years of presiding over cases in the administrative realm as a hearing officer, 3 years as a hearing officer and 2.5 years as a supervisor, that's what I have a lot of experience with. And what I've learned is, as people come into court, as Mr. Lester said, they're not there on the best day. Emotions are running high. And you've got to have a lot of patience to be able to allow those emotions to come out to an extent, but also manage those party emotions, particularly in a pro se docket, because that's what the judge is charged to do. I mean, you're doing a lot of what the attorneys otherwise would be doing. But to manage those party emotions and to be able to direct the parties forward. You do that by listening. You do that by keeping an open mind. By doing so, I mean, this is their day in court. You're affording them the opportunity to present their case, to voice their concerns, and to have somebody that they trust is impartial to listen and to be able to make a decision based on those facts.
I wanted to ask you all, if I could, about specialty courts. I know that things like mental health court, drug court, that kind of thing have become more prevalent. I wanted to ask you all, sort of in general, how you feel those work, where they do well, where they fall short, and what are some specialty courts that you would like to see that aren't available right now. And let's start with Mr. Lester.
Thank you. The specialty courts are a mixed bag, so to speak. Down in Miami, they have baby court. They have all types of different courts that would never fly up here in Central Florida and in North Florida. The court that is, specialty court that is most successful is the problem-solving court, perhaps in Orange County. And there is a good mental health program in Orange County. Seminole County is burdened by the fact we're a smaller county and we don't have the court budget necessarily that can afford all these types of specialty courts. When it comes down to brass tacks, what you have at the intersection of poverty and mental health is a situation where you are going to need somebody to come in there and assist these folks in getting back on track. In county court, we don't have the resources for that. The best thing that we can do in county court, the most bang for the buck to keep people out of the system, would be a specialty driver's license court. That is the root of all evil in misdemeanor court. That is where people get on the slippery slope to not getting out of trouble. I've seen people with felonies in circuit court out of driver's license suspensions. That would be the one specialty court that we could assist people in. The Veterans Court does very well. The mental health court does very well. The drug court does okay. I have a difference of philosophy with the drug court to the extent that they wanted to go for the very hardcore drug users. I wanted to go for the very first time drug users, and I thought it would be more equitable to them, keep them out of trouble, get them going. There was reasons why they went that way years ago and everything. And to this date, I think we've realized that now it takes more than a drug court, so to speak. It takes a system set up like the sheriff is doing to deal with some of these hardcore drug users. But in misdemeanor court, the most bang for your buck would be with a specialty court centered around driver's license.
Thank you for that. Mr. Swenk?
Yes, I think Judge Woodard has done an excellent job creating and maintaining our specialty court system in Seminole County. We've got the mental health courts, the veterans court, and as Mr. Lester mentioned, the drug court. I would have to agree that, a branch of the drug court is something that I would, or substance abuse anyways, would be something that I could see beneficial for the county court, for first-time abusers. Coming from facing those life challenges myself, it's one of the reasons why I feel like I'm being called to this bench and one of the reasons why I stay so heavily involved in our community is to understand the community issues that we face and also to understand the many community resources that we have available to address some of these issues so that when people are coming into our courts, and you mentioned this a little briefly earlier, that we're not just there ruling on the cases at hand, but when we see the underlying issues that are bringing people in, that we can address those. We're in a unique position as a judge to be able to address some of those underlying issues, and knowing some of the community resources that we have available to address those issues is critical. And if we have an additional specialty court to address some of those first-time users, it's a way to divert them and hopefully get them back on the right track as well. Similar to what I had some really good resources, some really good people in my corner, and not everybody has that. We have a lot of people that come in that do not have those resources. And if I can be there to provide those resources and help and save a life, then that's the whole purpose of me being there.
Thank you. Ms. Buie?
Yes, I think specialty courts are good things to have and set up in the court system, the mental health, the veterans court, as well as the drug court. Drug court and mental health courts, they can, and as well as the veteran courts they deal with veterans specifically, but drug court and mental health courts, they deal with the average person who are going through difficult times or who are struggling with an addiction. As far as drug court, mental health court is something that we people don't understand mental health a lot. So when you take them out of the criminal system and put them in their own separate court, I think that does more good for them than it and the society, because then it puts them in a situation where they can get help. As far as the drug court, it does the same. Drug court is drugs are an addiction, and sometimes people don't know how to handle the addiction, but if you give them the tools that they need, which is what I believe drug court is set up for, and drug court also takes care of like other areas. I know when I was in dependency, and when I practiced dependency in Volusia County, if the parent had drug abuse issue, then what they would do would they would send them over to the drug court and also help them to maybe get themselves clean. And so the drug court would work with the dependency court, so the parent would be able to keep their child, or either stand a better chance to get off of drugs and get clean, so that they can get their child reunified with them. So I see the specialty courts as something that actually is needed, especially when you know and you have people in there who understand what is going on and people who are there to help. And I think that maybe we can use the drug court and dependency court as well. That should be something that they could consider in Seminole County to help the parents who are on drugs to kind of get some help for their addiction.
Okay.
Thank you, Ms. Bowie.
I wanted to ask you guys a couple of questions in a row, and maybe these can sort of be lightning round questions with just quick answers. One is that I think lawyers are sometimes members of ideological legal groups or societies, and I think voters are paying more attention to those affiliations these days. So I'm wondering if each of you is a member of any such group, like the Federalist Society or the American Constitution Society, and if so, why you're a member of that group. And Mr. Swenk, maybe we can start with you.
So I am a member of a number of organizations. I'm not sure if it's appropriate to answer the ones that are party affiliated, because we're prohibited from canon from discussing party affiliation. And I know some of them can lean towards those resources. I do have them listed on my Facebook page, that I'm a member of. However, I am a member of a number of organizations, the ones that I can refer to. I'm a vice president of Heroes Strong, which is a local nonprofit organization, and we honor our community heroes, essentially military, first responders, medical and education fields, for the everyday sacrifices they make. It's near and dear to my heart, with my dad being a police officer for 28 years with Orlando. We've got a lot of organizations out there that offer resources for people who have been injured or, God forbid, fatally wounded, but not a lot of organizations, as far as I know, we're the only one that supports the everyday sacrifices. The officer that is serving on a holiday while his family is celebrating Christmas.
Okay.
Things like that. I'm a board of trustees of the Central Florida Zoo and a number of chambers. And
I appreciate that. I wasn't really interested in the nonprofit. I was interested in the ideological. Maybe you can just let me know if you are a member of the Federalist Society or the American Constitution Society.
Yeah, I'd rather avoid answering those, just to avoid any violation of possible canon.
I don't believe we've heard that before, but okay, duly noted. Ms. Bowie?
I am not sure if you answer yes or no, if that would be a violation of the canon, but going off of what Ms. Krys said, that you all would not ask any questions that will violate our judicial canon. I am assuming that you have reviewed those questions, and the answer to that question would be no. I am not a member of either of those societies.
Okay, thank you. And Mr. Lester?
No, I'm a member of no society. As a mentored judge for 15 years, as soon as a new judge comes in and I mentored them, I tell them, get out of these organizations immediately.
Okay.
You don't have any ties.
Thank you very much. And a little one that you might be a little more open-ended. A lot of voters are interested in endorsements, especially in judges' races. I'm wondering if any of you has any endorsement. I don't need you to list them all, but any particular endorsement by an individual or group that you think voters should know about. And Ms. Buie, we can start with you.
No, just my family and friends and the community have endorsed me to run for this position.
Okay, Mr. Swenk?
Yeah, a number of endorsements, and people can find those on my website. Notably, Commissioner or Mayor Matt Morgan of Longwood, Abby Sanchez, Seminole County School Board, Commissioner Jim Turney with Altamont Springs, a number of community leaders as well.
Okay, thank you. And Mr. Lester.
And I have the sheriff, I have the state attorney, the chief public defender, the property appraiser, the clerk of court, and most of my fellow USA Wrestling coaches in the Central Florida area.
Okay. Thank you very much.
Thank you. Thank
You're
you
welcome.
very much. One of the experiences that we all went through during COVID was an increased reliance on online appearances like this one, where you don't necessarily have to ask litigants to travel to a courtroom. You can ask them to appear remotely. What, if any, of those opportunities should the courts maintain once everybody agrees that COVID is over? And we will start with Ms. Buie.
I think that there are some procedures in court that you need to be face-to-face with, and then I think there are some procedures that are okay with being over Zoom or Teams or whatever system you choose to use. But I just believe that, so it would be on a case-by-case or a case-by-case basis as to what should be heard in person and what should be done via Zoom. I think Zoom or Teams or over the internet, however you want to say it, is something that has, I believe, complemented the court system. And I think it is very useful in some circumstances, but it also has its drawbacks in others. So in like trials, I think would be something that's a little difficult. I know that they do them, but it's a little difficult and over Zoom versus in person. Like a judicial review for a dependency, that would be something that I believe that you could do over Zoom versus, having to call all the people into court. So there are some pros and cons, and I think it would be on a case-by-case basis.
All right, Mr. Swenk.
Yes, so I would agree. I think virtual platforms are a great complement to the court system, specifically for non-evidentiary hearings. At the very beginning of COVID, we ended up with my office implementing a virtual platform so that we could continue proceeding with hearings in the wake of people not being able to appear in person to a physical location. We provided a virtual platform to be able to accommodate that. And myself and one of my hearing officers on my team were the ones that created that platform, implemented it, put the rules together, and instructed our entire office on how to move forward with those. We still use that today. I know the court systems still utilize it. We use Microsoft Teams, but I'm also familiar with Zoom and Google Meets because we were looking at all three of those platforms when we were looking at which platform to use. We just ended up landing on Teams because that's what the state and our office was using at the time. But I think it's something that's absolutely beneficial. It saves attorneys time from having to go into the courtroom when they could be spending that time on other parts of their cases for their clients. Otherwise, maybe even allowing some additional time for comfort of living, being at their homes with their families. Same thing with the clients or with the parties. I mean, allowing them to appear, saves them the burden of transportation when they might not have viable means of transportation.
Mr. Lester.
Thank you. We've actually been down this road before in the criminal system because we had electronic search warrants always available for a number of years. I've never signed an electronic search warrant. I've always tell the officers to come in. I want to talk to them. There's some things you can't see over a screen that you can't read off of a pad. You have to see people face to face. You got to remember, county court is 80% criminal. You have to see microbursts of expressions. You hear a little exhalation. You have to have these little intimate human experiences when you are trying to figure out what's going on with a particular situation. As far as saving costs, I'm all for saving costs. I'm all for cutting the budget down, saving the state some money, but it's got to be efficient and effective, but not compromising a person's right to their day in court. We can do that. We've done it for years on end. We're doing it now. It's available, whatever way you want to do it, Zoom or Teams, but that's not the real issue. The real issue is making sure you can give this person a good day in court and a fair hearing and protect their constitutional rights.
Thank you very much. And I wanted to sneak in one more question along those lines, which is that county judges deal with sometimes dozens of cases a day. What are the most important things to keep in mind as a judge works to keep his or her docket moving? And we will start with Mr. Swenk.
Well, with our office, we don't have as large of a docket that county court would have. I think I presided over 1,600 plus cases in 3 years, which is still a significant amount. What impact we have on our dockets is that we have deadlines that are very quick. So a lot of our hearings we have to have between the hearing request and our decision. We have to have a decision within 60 days on some programs and 90 days on another. So we've got very, very quick deadlines that we need to turn around on. So minding those deadlines is very important. As Mr. Lester had mentioned, due process is critical in any case that comes before us, and ensuring that due process means allowing that case to move forward and ensuring that it does. So minding deadlines, I think, is critical in making sure that the dockets are moving forward and where they're addressing the cases timely and effectively.
Thank you. Mr. Lester?
Again, here's the reality of the situation. As a circuit court judge, there were days when I had 300 people dockets, 300 person dockets. The way you move these along is you make sure the attorneys know what they're doing ahead of time. It's not essential for the clients to actually be in court if they're just moving to continue a case. Additionally, you want to make sure that the clients understand exactly when they're supposed to be back in court, what their expectations are as far as what they're supposed to be doing. If they are not going to be a candidate for probation, and you can tell fairly early on if people have been through the system before and they're not doing things, you may want to start discussing with the state and with the defense attorney things they can do before they come to court so that they can get these things accomplished, such as get your driver's license so I don't have to put you on probation and get out of here. And those are the types of things that not only save you time in court on that day, but also in the long run. That's how you get your docket down. When you go to court and you're sitting in court, lots of times people who are pro se at that stage see what's going on and see that people are being dealt with fairly and completely, and they get the idea that they are not going to be cheated or treated improperly, and that they start to understand what's going on. So when I say sit down and talk with this attorney, they will feel that they are going to be treated correctly. And that's what happens as you go through these dockets. You take them in a very specific order as far as the people and the types of cases and things of that sort. You'd like to get some pleas done so that people will see what actually goes on in a court. You have to go through the colloquy with them. It takes years of experience. What's interesting is that all these years, right after the elections, as I sat on the bench, I would invariably see a person in a pair of street clothes come in with a long legal pad and start scribbling down what's going on in court. I could say it's a little late now to learn what's going on in court. I'm happy that you just got elected over in Orange County or Volusia County. And that's why you're here in Seminole County, because you don't want them to see you. But it's a little late now to start learning what's going on in court. That's the one thing you don't have to worry about with me. I've been there.
Yeah. Ms. Buie?
I'm sorry, can you repeat the question again for me?
How do you, when you are facing a docket of dozens or hundreds of cases, how do you make sure that things keep moving efficiently and still maintaining the proper protections of law?
Okay, well, I believe time management is very essential. I remember when I first started out as an assistant public defender, and of course we had plenty of cases, and so my caseload was very high. But I remember like one judge particular would give us an opportunity to meet with the state attorney's office or meet with our clients to say, get an offer from the state and then relay it to our client. So by the time we got to the cases were called, everyone would pretty much know. So it would be like maybe 30 minutes. So we'd have everyone come in 30 minutes ahead of time before court actually got started. So maybe if court gets started at 9, come in at 8:30. They have an opportunity, if they have not spoken to their attorney, to meet their attorney. And then the attorney can just get up and say, this is what we're going to do. We're going to plead. We're going to ask for a continuance. We're going to set it for trial. So it doesn't take a lot of time as we're standing up at the bench. You're trying to talk to your client, say, hey, what do you want to do? And then your client is trying to so I believe time management is very important. And then that is something that I had learned as an assistant public defender, and as well as talking with having clients as parents in the dependency system and how to try and manage that time.
Thank you. Well, we have come actually to the end of our time. I very much enjoyed talking to all of you, and I'm sure Jay and Scott did as well. And I just wanted to invite you to make a closing statement as to why you would be the best choice for this role. Let's start with Mr. Lester.
I've enjoyed being here today. It's one of those situations where you don't often get being asked questions as a former judge. I usually get to do the questioning myself, so it's good to be in the hot seat every now and then. The thing that I bring to this situation that we call an election is experience. Experience not only as a private attorney, experience as a young man, a teenager in Vietnam and combat, experience as a business owner, experience as a judge. I think that well-rounded experience in the community lends itself to this particular position here in the People's Court. Some people think that it's a pro se heavy docket. It certainly isn't for the most part. Not when I'm in court running this type of situation. I make sure people get attorneys. I like to have an open and transparent court. I remember back when Renee Stutzman from your office was there, and we started off. She wanted to see how plea bargaining took place. I invited her back into chambers so she could sit down and actually see how plea bargaining took place. Here are the attorneys. So you have to be open and transparent. There's been a problem in Seminole County. Nobody can get around it. I've checked the pipes in the new courthouse. I'm making sure they're not using any lead soldering over there. So I don't think we can blame it on the water in Seminole County anymore. But I think we have to realize that the people of Seminole County demand a good, solid judiciary. Someone who's not going to embarrass somebody who has a track record, somebody who has experience, and somebody who they can count on. I think they can find that in me. Thank you very much for your time.
Ms. Buie.
Yes, I just want to say that I love Seminole County. Seminole County is home to me. This is where I grew up. This is where I attended school, public school, from elementary to high school. I went away to college, went away for a job for a couple of years, came back to Seminole County. Seminole County is home. This is where I want to serve. This is where I want to be. This is my community, and no better place for me to serve my community than as a judge. I will be fair. I will be impartial. I'm honest. I have integrity. And I believe that I will follow the law. I know that I will be a good judge for those in Seminole County, for the residents of Seminole County, the citizens of Seminole County. I want to be able to share what I know with the citizens of Seminole County as a judge and in my service to the community.
Thank you. And finally, Mr. Swenk.
Yes. So experience. Yeah, again, I believe our county court deserves a judge that's got experience with a largely pro se docket, and that's what I have. What I inform people also is, we've got a Florida State Constitution, Article 5, Section 8 states that no judge shall serve past the age of 75. What I regularly inform people is I'm the only one out of the three of us that has the experience in adjudication, but can also finish the term. I think one of the other things that really differentiates myself from the other candidates is my personal experience of going through a lot of these life challenges that bring people into court. Having somebody on the bench that's gone through that and can relate and ties themselves in to the community issues and resources available to try to help those people, to have a passion for that, I think is very important. And I think it's something that our county court really needs. And I think it's something our county court deserves.
Well, I thank you all very much. I want to remind everybody that this race will be open to all voters in Seminole County. And the primary is August 23rd. If one of you does not secure 50% plus one of the vote, it will go forward to the November ballot. And I thank you once more, and I look forward to seeing the results of the election. Have a great day.